Hello and welcome to Search and Seizure in the Digital Realm. My name is Brian Chase and I am Director of Digital Forensics at Archer Hall. Archer Hall is a digital forensics company that does work nationwide. We collect data from digital sources such as cell phones, computers, external hard drives, email accounts, cloud accounts, social media data. We collect that data, we analyze it, we testify about it at trial. We also offer e-discovery services where we take that data and we put it in a hosted review platform. My personal background, I am a licensed attorney in Arizona and New York. I practiced law for about 10 years, doing mostly plaintiff personal injury and criminal defense. I've tried cases as an attorney. I've been doing digital forensics work for about 8 years, and I've testified about 20 times as an expert witness in digital forensics. In addition to my work at Archer Hall, I also teach at the University of Arizona, James E. Rogers College of Law. I teach a trial skills course there at the law school. Today's presentation really combines both areas of my background, both the criminal defense work and the digital forensics work. We're going to be talking about Fourth and Fifth Amendment law as it relates to digital evidence. Our course today is based entirely on federal law, on U.S. Constitution, Fourth and Fifth Amendment. Your state constitution and your state laws might differ somewhat from the federal level. Be sure that you check your local jurisdiction if you're dealing in state court as opposed to federal court. But let's get started today by discussing the legal framework. We're going to start by talking about Fourth Amendment law. We're going to be talking about that search law of the Fourth Amendment. When do we have a search when we're talking about digital evidence, and when is a warrant required for those searches? So we're going to get into it by starting with U.S. v. Jones, a 2012 decision from the U.S. Supreme Court. You're probably familiar with Jones, but as a recap, Jones was a case where the government installed a GPS tracking device on Mr. Jones' vehicle. They then monitored his vehicle for 30 days. They did this without a warrant. The case went up to the U.S. Supreme Court, and the Supreme Court held Justice Scalia, writing for the majority, found that this was a trespass. Installing the GPS device on Mr. Jones' vehicle was a trespass without a warrant, and therefore it was unlawful. Now, in order to raise trespass, the defendant must have standing. They must have an interest in the subject that is being searched. In this case, Mr. Jones actually did not own the vehicle. The vehicle was owned by his girlfriend or his wife, but the government knew that he was the primary driver of it. That's why they were installing the GPS device on this vehicle, because they were trying to track him. So he clearly had standing to challenge this trespass. Now, when we go to the concurring decisions from Alito and Sotomayor, they looked at this not from a trespass standpoint, but from a reasonable expectation of privacy. And they looked at it of long-term versus short-term. Short-term would not violate somebody's reasonable expectation of privacy. Had they only installed that GPS tracking device for a day, that probably would not violate his reasonable expectation of privacy. Certainly, the government could have put an officer in a vehicle and trailed Mr. Jones for a day. His movement in public like that would not violate his expectation of privacy. But once it moved to long-term tracking, then it impinges on the expectation of privacy. Now, the court didn't tell us when something moves from short-term to long-term. They just told us that surely it crossed the line before the 4-week mark. When did it cross the line before the 4-week mark? Well, we don't know. Although I will suggest to you that it's potentially at the 7-day mark. And we'll see that come up again in a little bit when we talk about Carpenter. So just keep that in mind until we get to Carpenter. But for now, with Jones, all we know is that long-term monitoring using the GPS device violated that reasonable expectation of privacy, and therefore a warrant was required. Let's then move on now to Riley.